Right. Thank you for having me at the panel. The question I will address in this presentation is whether trade agreements, whether trade policies can accommodate gender equality. To address this question, we'll first look at the problem, then we'll see how existing trade policies can solve the problem. And finally, we will look at some hesitations that countries have faced in accepting such gender mainstreaming initiatives in their trade agreements, in their trade policies. So let's look at the problem first. The problem is that women face barriers, various barriers that impede their access to markets and economic opportunities. Now, these barriers include lack of access to education, productive resources, finance, household responsibilities, and disproportionate tariffs, famously known as pink tariffs. And the pandemic, as we know, has magnified the impact of all these barriers, more so for women with massive loss of jobs in service industry, trade restrictions on food products to ensure food security or to stop the spread of virus, and reduced access to education, mobility, and networking opportunities for women. So, what can we do to help women overcome these problems? Well, we really have two options or two different approaches to deal with these challenges. We can either employ a bottom up or a top down approach. So, we either directly change the national laws, culture, social norms at the domestic level, or we use international law to create an incentive to bring about this change at the domestic level. I have employed the top down approach in my research work as I have tried to explore how the existing trade policy instruments, including trade agreements, have the potential to effectively engage and empower women in trade. Um, and trade policies as such can be used for two different reasons: diplomatic and substantive. Trade policies or trade agreements can play an important role in reducing gender inequality because countries can engage their trade partners to create laws and procedures that can reduce barriers and create encouraging conditions for women's participation in trade and commerce. So, in this manner, countries can use these negotiating instruments to, in a way, incentivize change at the domestic level in other countries in exchange for an enhanced or an unfettered market access. So, what we are trying to use through these negotiating instruments is a layer of market access to other important markets. And the second reason is substantive. Well, trade policies can work because gender equality has a business case to it. McKinsey and other studies have shown that world economy will only get richer if gender parity is achieved in the next few years. So, while gone are the days when gender equality or inequality was viewed as a purely ethical or a purely moral concern, it has now been recognized as a significant challenge to economic development. And that leads to the understanding that trade and gender have a bidirectional relationship because trade impacts the degree and forms of gender inequalities, as we know. But on the other hand, gender inequalities also impact trade strategies, trade policies, trade outcomes, and even productiveness. Trade agreements can help. Various research by scholars, by think tanks, by international organizations have in the last few years shown that trade agreements can help strengthen women empowerment. And it is so interesting to see that more and more countries now are including gender concerns in their trade agreements, right? The agreements with gender provisions are on a steep rise. And this rise, the stark increase, mainly can be seen from 2016 onwards. Different countries have added provisions on gender in various ways. And they have assumed commitments on increasing women's access to education, access to markets, access to other resources, digital skills, representation in decision-making roles, protection of lives of women in conflict and violence-like situations, and elimination of discrimination or employment discrimination. These are different kinds of gender explicit or gender related provisions that countries have negotiated in their trade agreements so far. And these provisions have, as per the research by the WTO Economic Research and Stats Division, these provisions on gender have been added in different parts of these agreements, including in preamble or annex or side agreement or a standalone chapter on trade and gender. And they have also been drafted in different ways, because some provisions have been drafted in the preamble, some provisions on gender, some commitments on gender have found their way in the chapter on fisheries, in the chapter on investment, in the chapter on electronic commerce, government procurement, and SMEs, and so on and so forth. Some countries have clearly pioneered the inclusion of gender provisions in their agreements, and others have stayed far away from such discussions for various reasons. These hesitations include lack of data to show how they relate to each other, how trade and gender are related, general belief that trade policies are only for trade and not to solve social problems. Hesitations could also include lack of political will. It could include fears that more developed countries, well, developing countries can have fears that more developed countries can use such gender commitments or gender provisions in a protectionist manner so as to reduce their comparative advantage or impose their moral standards on other countries. And these fears of protectionism can lead to concerns relating to moral imperialism or cultural imperialism. What may be morally right in your country may not be morally right for mine, right? Let's try and look at a WTO case to understand this concern. Now, if you look at EC seals, the EU seals case, this is one case where the decision can be seen as legitimizing moral imperialism, because it is possible to argue that moral imperialism was inherent in the EU seal regime, because the ban, the measure, could be seen as an attempt by the EU to impose its own moral values or moral standards onto foreign jurisdictions without any consideration for their moral values. Now, this imposition, in a sense, also went against the traditions and cultural practices related to seal hunting in other countries, including Canada and Norway. So, by giving legitimacy to animal welfare concern as a public moral concern, both the WTO panel and the appellate body subordinated, in a way, the moral concerns of the indigenous sealing communities in other countries to those of the EU's animal welfare concerns. Now, this is a classic example that reflects how justifying a trade measure under a vaguely defined value, such as public morality or gender equality, of course, because gender equality commitments have been included in trade agreements and trade policies without defining this expression. It may allow the responding country to effectively define the moral concerns of foreign jurisdictions without any regard whatsoever for their morals, or even sometimes at the cost of destroying their comparative advantage, either in a particular product or in a particular industry. Another barrier that could discourage countries to accept trade and gender related developments, and I think that these concerns would apply when it comes to accepting gender provisions in trade agreements, when they're negotiating trade agreements or trade and gender developments, such as the the WTO Gender Declaration at the Multilateral Trading Forum. Another barrier that could sort of discourage these efforts could be the high cost of compliance and the low probability of compliance with such commitments. Countries' willingness and appetite for such inducements generally rely on their domestic conditions, as countries may not be willing to be a part of an agreement that contains obligations they simply cannot comply with. So, countries with practices and policies that do not discourage gender inequality um, and, and do not comply with countries that do not comply with commonly accepted norms, such as elimination of discrimination based on sex under CEDAW 1979, might be less likely to accept such a provision. Though the African countries and the trade agreements seem to go against this theory, and we'll see that in a few minutes as to why it goes against this theory. Lack of data is another impediment, especially for developing countries, as they simply may not have the required capacity to gather the kind of gender disaggregated data needed for enforcing such commitments or for assessing the gender impact of trade agreements they have negotiated. And another barrier could be the lack of understanding and the lack of expertise to deal with trade and gender issues together, right? What does it mean to negotiate a trade agreement with a gender lens? What is gender responsiveness? How should an agreement be negotiated so it is gender responsive, right? Oftentimes, the understanding of these expressions and the understanding of these processes is missing. So, to overcome this barrier in particular, ITC, International Trade Center, has prepared a methodology to measure the gender responsiveness of free trade agreements. Now, this, as you can see here, is a maturity framework which can help policymakers measure gender responsiveness of agreements they are negotiating or looking to renegotiate or modernize. The questions in this framework try to gauge different ways in which countries incorporate gender provisions, for example, by assessing the frequency, location, nature, wording of these provisions. After all the questions are answered, the agreement receives a level of gender responsiveness and a score of gender responsiveness. Now, what did we find when we applied this framework, when we applied this methodology to the existing agreements? Now, after reviewing some 400 plus trade agreements, bilateral, regional, preferential trade agreements, and measuring their gender responsiveness using this framework, this is what we have found. This map gives you a fair idea of countries that include gender commitments in their trade agreements and the ones that don't. There are specific things to note here. First, the regions that have signed the most gender responsive agreements are North America and East Africa. In fact, East Africa has signed some of the most responsive agreements with binding legal obligations. Number two, as you can see, European Union is closely following the trail of the pioneers in gender mainstreaming. But of course, it still has a long way to go in terms of mainstreaming gender in their trade agreements, because so far they have not front-loaded but back-loaded gender provisions in their trade and sustainable development chapters and provisions. And number three, different regions, as you can see here, I have only identified several best practice provisions from different regions on this map. But different regions have different ways of including these commitments. Canada seeks to use its agreements to enhance women's access to education, finance, and business opportunities. Then, if you look at how EU is doing it, EU uses its trade agreements to enhance women's access to health services, reduce violence against women, and protect women's lives. And then when we look at East Africa, the trade agreements negotiated by East African countries tend to increase women's representation in decision-making and policy-making roles. So these kind of provisions are only specific to this region because they have not been negotiated by trade agreement in trade agreements by other countries, by other regions, right? So gender mainstreaming in trade agreements is quite diverse, and it changes from one region to the other in its drafting style, in its focus, in its topic coverage, and in its nature and scope. But there are three things which are common to most of the trade agreements that include at least one explicit commitment on gender. Well, as we know, there are some 400 plus trade agreements that are in force today. How many of them include an explicit provision on gender? Just about 20%. Just about 20% of these trade agreements include at least one commitment which is gender explicit. But there's something which is common in most of these agreements that include gender commitments. And there are three things, in fact, not something, but three things. First, most of these commitments are drafted as best endeavor promises, and they have been excluded from the scope, from the jurisdiction of the agreement's dispute settlement mechanism. So they cannot be enforced. Second, countries have made these commitments without identifying institutions or procedures to implement them. And third, these Cinderella provisions have been added without countries making an effort to identify or talk about or plan as to how they are going to go about mobilizing resources for implementing these promises. For example, when they talk about increasing women's access to STEM education, how will they go about financing those activities? Is a procedural aspect which is missing. With no enforcement, no implementation mechanism, and no finance, it is difficult to see how such provisions will ever be put to action. So I would like to conclude this presentation with three questions. First, the new generation free trade agreements such as USMCA, they contain highly enforceable labor commitments. If this can be negotiated, I wonder why countries are still reluctant to include enforceable gender-related commitments such as equal pay for equal work. The concerns and hesitations we have discussed in this presentation in respect of gender commitments may also be valid for labor standards, right? Moral concerns, moral imperialism or cultural imperialism concerns, cost of compliance and probability of compliance concerns, understanding and expertise concerns, that are equally applicable to labor standards. But then we have seen the recent trade agreements coming up with such highly enforceable labor standards, but we have not seen that filtration of enforceable gender provisions happening in trade agreements. My second question is, if we can have exceptions to protect public morals, animal health or life, plant health or life, and almost pretty much every single existing trade agreement, can we think about negotiating an exception to reduce gender inequality? Or can we invoke public morality exception, Article 20A, to protect women's economic interests? Does that amount to public morality protection? And my last question is, if these gender provisions are not made enforceable, if they're not drafted in the form of a legally binding commitment, wouldn't they remain a distant reality if parties do not craft procedures and institutions to put these provisions into action? And I would like to conclude with these three questions, and I look forward to questions and discussions about this paper at the conference.